Further also, item number 51 also, we file an affidavit in reply. That is not connected. Maybe listed on Wednesday along with this.
One.
Supplementary
Council. File an affidavit.
in reply.
Given the affidavit. However, it's not connected to the case report registry to stop the affidavit. Case this matter again on Wednesday or Friday?
Friday is holiday.
Friday is a holiday. No, Friday is not a holiday. Friday, okay. Wednesday.
Interim order may candidate.
Huh?
Interim order may candidate.
Whatever is there is there. Why do you want to extend an interim?
Otherwise also they make advertisement and also.
Why did you file the affidavit today when the matter is fixed?
No,
when did you file it?
It was filed on Thursday. No?
Then you
Not connected. No?
Then you have to bring it to the past only.
Sir, Lordship, I'd like to mention item number 25, your Lordship. Lordship, there are talks of some settlement still going on between parties, your Lordship.
You're mentioning on
behalf of the respondent, the arbitration petition, your Lordship.
On behalf of the petitioner.
Respondent in the arbitration.
Who's for the petitioner?
We have their consent, your Lordship.
Item 25 only request by counsel for this process stands referred to Mr. Dr. Pool.
Please, Lordship, I beg to mention item 38, your Lordship. Mr. Irascal Leonard counsel is today no.
Hearing will continue, then we'll have to fix a date. Why is the matter fixed today?
So it's really this for some argument. Can you fix it on?
Who's for the respondent?
Respondent is elementary.
Have you called the counsel?
We have already taken their consent.
Then should make use of this adjournment sleep.
Actually, for yesterday itself, this all this
stands deferred. Seventh of April. The models.
I beg to mention for listing of matter is in order column.
Order column April 27 April.
Item number 42. Whether I am the petitioner, I want to file my affidavit in reply. From that
42 on the request made by the council.
My lord, which order is taking this matter? And its name may be reflected. Which order?
On the next date, you make a mention.
Item 15 for an adjournment.
Item
15.
1-5.
Conducting counsel is it's a medical urgency in Canada.
Item 15 stands deferred to be listed after 1 week.
Lordship, on
Monday. Next Monday.
Next month.
6th. Let's break for. 6th of Mr. Nath for the response.
I beg to mention.
Any objection, Mr. Nath?
For the respondent.
The objection on sorry, on 6th.
I beg to mention item 6 and 11.
6
There's a transfer orders are challenging matters. Matters will take these matters
Similar matters are fixed on after vacation.
What's the date?
20,
When are these similar matters fixed?
29 matters.
29th of April. 29th, items 6 and 11.
11.
The request made by the council for the stand referred to be listed on 29th of 11. As it is submitted, the similar matters are fixed.
Obliged.
He submits that.
Wait, please, Lordship, I beg to mention item number 40, with the consent of the other side,
1440.
40. Council is unable to appear.
Which matter? For whom?
Petitioner,
For the petitioner. What difficulty? It's a part-heard matter.
personally,
It's a part-heard matter.
part,
It's a
Pardon?
part-heard matter.
part-heard matter.
Have you informed the other side? Item 40 be listed. After 4 weeks.
Depending on the
Hearing for this one. It's made by the council. Further or partner. Can't pass over the first item. Be reasonable in your praise. Party. Yeah, please go on. It's better. After the petitioner will take appropriate steps to serve as the purpose. Standing counsel for all the.
Just few questions regarding whether legal layers of the description has been filed for appointment of arbitrators. But kindly pass over the matter of my senior appraisal. Proceeds at page 59.
Is it a company? It's a company.
Yes, it's a company.
You need to have the authorization.
We have,
Yes, the board of director resolution is not there, Your Lordship. The affidavit we have mentioned that is
You
been
mentioned,
authorized.
but there must be something. Support. But Mr. D. Senapati learned. 6th of February 2008.
You are appearing.
Yes, sir.
Was terminated. Agreement terminated.
I think, yes, there was a arbitration already. There was an arbitration award also.
Set aside.
that has been set aside. So we are coming, since there's no appeal been preferred against that. We have mentioned it at para 7.
Mr. P. Naik appears for respondent number
1.
big one.
Yes, sir.
Sole respondent. They put says the waive extra copy. Yeah.
Lordship, this is a contempt petition where the order dated 02/06/2025 is not complied, your lordship. The relevant portion is at page 12, your lordship. Para 7. View of the above and on the consent of the parties, the responding authorities are directed to verify the service
Correct.
particulars.
Steps of the respondent by speed post. Just after returnability. You are under suspension,
No one. Reinstated.
reinstated.
After reinstatement, I should have been the regular salary method. They have filed the affidavit in this case number. Admitted that after
Where is that page number?
paragraph 41, page 41, my lord. The affidavit. Paragraph 5 and 6.
There are 5.
5 and 6, my lord. In paragraph 5, they have admitted that during the area amount of summary. Paragraph 6, they have admitted that after reinstatement,
Where is that order of the court being referred to here? 6871.
find the order at page 22, man. The order, madam, there is no, because direction was made to reinstate the petitioner.
I heard counsel for parties, the petition. Despite of the petitioner being reinstated in service, salary as due has not been released, rather being paid salary at the rate of 75%. So counsel for the petitioner submits that there is no explanation as to why the petitioner is not being paid his salary as due. So when this matter was filed, the respondents were permitted time to obtain their instructions. So they have filed their affidavit where at para 5, the following amendments are made. Where is 687, WPC 687?
6871, it should have been 6871. The
Page 22 onwards.
minus.
Para 5 and 6 to the extract code. Page number 14. The affidavit see that the respondent does not dispute the petitioner is entitled to his claim salary. So see that the matter is pending for approval of the government. Under such circumstances, so consider the government to release all area salary within a period of 60 days from the date of receipt of a certificate of payment. So, needless to say, department will proceed to release. Needless to say, once the approval is granted by the state, the amount payable to the petitioner. This goes. Current salary payable to the petitioner. You're getting your current salary.
This salary we are getting.
Huh?
We are getting less money.
Less amount. The absence of any specific orders suspending the writ petitioner or interfering or directing. Lesser amount salary per month. The authority is concerned, we release the full amount salary payment. Item 7. Yes.
Herein in last occasion, instruction was what? Instruction regard to the stand of the.
Here I have received this instruction notice. As per instruction notice, as per earlier order of this honorable court, he was re-examined and subsequently he is found fit. And that result has been sent to SSC. And while the SSC is not declaring his result, that I have to take inspection, I need some more time. He is found fit.
He is found fit.
That is the.
In deference to the earlier order dated 9/3/26, the General CTC, Mr. P.S. Rathore, submits on instructions that upon re-evaluation, the petitioner has been found fit for the post of or appointment to the post of constable, GD.
Yes, sir.
Stop the evaluation re-evaluation undertaken is now presently pending before.
Respondent number two.
The result of the re-evaluation has been forwarded to the
Respondent number two, Lordship. SSC.
respondent to
SSC, Lordship. Subscript SSC. Represented
The-
by
SSC, respondent number two, pending their approval, which is pending their approval. Once the same is approved, case of the reputation again. Therefore, submits that further time be granted to the complete instruction. Considering the submissions made, please taken after 4 weeks.
on 21st, Lordship.
1st of April. After 3 weeks. 21st of 22nd of April.
Definitely kept in the record.
Want you take it? Take it.
I
Ah, right.
In this case, we are paying for compassionate family pension and other family pension benefit also.
Certain matters is difficult. Please understand that. You have your instructions, you are supposed to get your instructions. You're supposed to get your instructions. What has happened? At least you should be able to furnish the instructions. Might have been listed again day after. Aji ki bar Monday. On Wednesday.
On Wednesday, man, on Thursday, man. Not tomorrow. Friday.
Friday is a holiday.
Oh, sorry.
Wednesday. But Wednesday you have a problem.
Family, there's a family function.
All right, tomorrow.
But-
All right.
Instructions were called for in this matter, not receive any instruction, Lordship. Not receive any instruction, Lordship.
Mr. H.
Notice was not issued, Lordship.
Raise for further instructions, further time for instructions. That view of the matter led to decision written in 4 weeks. Mr. Chakraborty has entered appearance and accepted notice on behalf of all the respondents. So, text of furnished. Period of 1. Mr. Rai Ahmed. This after the returnable date.
Published.
Last week, also instruct why the promotions have not been affected by the form, because they were initially they are named in the general petition list of the state. Now they are saying that they will not do it. That is the case.
Yes.
Yes, Lordship, I have received the instruction.
What does it say?
And may I read, Lordship? BTR, the incumbents working under the 6th civil district of BTR, Dima Hasao and Karbi Anglong are incorporated in the state level gradation list where the incumbents working under 6th civil of so and so are excluded from the gradation list. The appointment and promotion of grade 3 and 4 posts are under the jurisdiction of 6th civil district authority. It is pertinent to mention here the BTC authority is the appointing authority of grade 3 and 4 posts. They are sole competent authority to give promotion to the next higher post. The BTC, as per my instruction, BTC is the competent authority for them.
They are, what service rules governs them?
Service,
Same set of,
same set of service.
so under the same set of rules, their names will have to be included in that gradation list for them to be considered for promotion, for higher posts. How can you exclude them because they are working under 6 schedule? First, their names will have to be included.
Their names were there.
Then and get this.
Now they have deleted us. And now they are saying that no, it is.
I need.
Like BTC has written to them. So give them.
I'll file affidavit. all
Affidavit
this
is
stuff.
fine, but unless the rules
Yes,
say so, or unless there are circulars or anything like that to show that BTC or a person working under 6 schedule have to be considered separately. Because prima facie it appears you're curtailing their rights of promotion. Because
but BTC.
even if the BTC authorities prepare a select list and promote them, finally they will only be able to get promotion to the posts which are available under BTC. They will have no claim over the posts across.
Now they are saying that they are appointing authority, they are the sole authority to promote.
Who has appointed you? BTC.
BTC.
Let us
Appointing
see
authority is
here,
BTC.
their affidavits be placed on record. Right.
In fact, one more thing. Earlier, just last year, 25, they have promoted from the BTC persons also. They have promoted. This time they have stated no. They have annexed that connection where they have given it from BTC persons also. Now they are saying after a particular date, that is on 8/9/25 they issue. Then
Let them
let
bring
them
it
come up
on record. Right. Mr. Y.S. Manan, Learned Counsel Commissioner, Mrs. Sharma, Standing Counsel, Health,
Health and family welfare.
Health and Family Welfare, appearing for respondents 1 and MS, Kashyap, appearing for respondents 3, 4, and 5, 3, 4, 5, 6. No, 3, 4, and 5. Ms. Sharma is for 1, 2, and 6.
1 to 6.
1 to 6.
Since the respondents are represented, books. This is the way the extra copies be furnished within a period of 1 day. Respondent will give their instructions and file necessary affidavits with advice is after the returnable bit.
Three weeks.
Yes, 3 weeks.
Instruction was support.
But letter some time may be granted, but here is unable to provide the instruction, they have to collect some of the records.
Heard terms of the parties to this returnable bit. Additional senior and paid appears. The respondents.
For the respondent.
All the respondents. Respondent find their affidavit. He to advise in the meeting.
The last program, the NSM authorities have verified the issue, but because of the code of conduct, they are not in a position to keep it in effect. They notice when to respond.
This may be issued till that manner, that transfer order will be suspended.
Where is that impugned order?
My lord. Impugned order, my lord, starts from, my lord, page number 20, my lord.
Relevant?
11, my lord. Page number 36, my lord. Serial number 254. Five.
So you were suspended and transferred.
Suspended on, my lord. Page number 15 is the suspension order.
done, now you are transferred.
Yes.
But Mr. Reyes, the told under council, Mr. Wage, state,
All the
the respondents. Serving as staff nurse, NHM, the Gauhati Medical College, by order dated 19/8/25, she was placed under suspension. The inquiry instituted. By
that my not lost. Record my, I will file my affidavit.
while the petitioner was under suspension by common order transfer issued by the NHM ID dated 16/2/2026. Is transferred from Kamrup Gauhati to Kimpu, Ambutsar, BPHC. Extending the transfer passed by the petitioner. As the petitioner was under suspension and his impugned transfer order is to be an order passed by way of punishment, although inquiry has been instituted against him. Last occasion, the learned additional lady was permitted time to obtain instructions. Submits that he received his instructions, he would like to bring it on record by way of an affidavit. That we have prepared. Their instructions and file necessary affidavit. C. Mr. Dubois has submitted the transfer order dated 19/8/25 is still in force and the petitioner is still under suspension. So, therefore, at this stage, this court is of the view that in the absence of any inquiry being conducted and final orders being passed by the disciplinary authority, transferring the petitioner under suspension from present place of posting him to the court. Circumstances in the next general day. Suspend, stay, transfer order. Directs the respondents not to give effect transfer order dated so and so only so far as the petitioner is concerned. This matter again. At the time of
Alia, madam.
The instruction was short form.
yes,
Recently, lots of the IMD has executed agreement with the Assam Agriculture University also. Pertaining the plan scheme CKMS. I have got the agreement along with the agreement for the state of Karnataka and Madhya Pradesh also.
the sum and substance of these tell us.
Financially, whatever after 31st, this fund was provided, madam. It is
Still, up to 31st March, the fund was released. The plan is scheme is continuing also. I have already annexed this MOUs executed with different universities from the state I am.
They are continuing the scheme through digital platforms.
But also the scheme is CKMS
Scheme may be there, but they don't want it to be manpower based.
But in terms of the original appointment also, they were appointed under ZKMS also. I have annexed the appointment orders also.
Where is that appointment order?
Appointment order is at page 37 also. On the recommendation of the selection committee and with the approval of the Vice Chancellor Assam Agriculture University.
If you see the bottom page, point number 3.
Agreed, Lordship. But the MOU that has been executed between the IMD and ICAR also, in terms of that agreement also, point 3.7, here services are co-terminus with the scheme also.
Where is the extension of the scheme?
Scheme, Lordship, I have got the agreements executed with the Assam Agriculture University from the side of the IMD Lordship. This is that it has been executed way back in 18/4/2024 Lordship.
Huh?
18/4/2024, the
Agreement for how many years?
and for another 5 years.
No, this is done subject to the finance being available.
Fund is admittedly fund was.
What do you say regarding this agreement being
This agreement-
executed?
And along with the,
You can file as many affidavits as you want, but then the interim order will have to be extended. Third counsel for parties issue notice return. Mr. S.K. Bedi, Respondents 1, 2, 5. Huh? 1, 2, 3, 5.
Well, 7 minutes, technical time.
For 6.
six
Six,
of
six.
IMD Lordship.
6 also, no? Arbora for respondent 4. I vote for 7.
But this agreement is within Assam Agriculture University,
We are, our nodal agency is Assam Agriculture.
not with Assam Agriculture University.
Assam Agriculture University and IMD Lordship.
Yes.
Why are you sending all papers here? Why can't
My-
you
my-
read
my
and tell
friend
us?
My friend, madam.
So
This
why are
is-
you
this is not-
sending it?
This is our agreement, madam.
This is the IMD and Agriculture University.
Used to pay your salary.
Lordship, the fund is to be released by the IMD. So it is paying.
So if it is not released, what happens?
No, Lordship, the admittedly fund was till 31st. They will, they may arrange a fresh fund also.
They may, if they don't,
And for the AMFU also, the other wing of ZKMS, their fund are also up to 31st March.
this insurance are reference to the earlier order dated 6. The SK Medi learned CEC has submits on instructions that the scheme that more specific instructions have been received with regard to extension or continuation. AMS scheme P131/3/2026. Therefore submits that if the scheme is not extended, there is no scope for retention of manpower like the grid condition. Therefore, they are sport service. And Mr. Das, the other end, submits that he has specific instructions that his scheme has been extended as an agreement has been executed between the
Indian Meteorological Department. and
Indian
Assam
Meteorological
Agriculture
Department
University.
and Assam Agricultural University, which is nodal agency. So therefore submits that the scheme is extended. There is no reason why the petitioner should be released. Hence, their services will be necessary for implementation of this. What do you say, respondent 4? Anything to submit? No.
Fine.
Sir, Quran and account submits that the scheme is evident that the scheme is to be continued till 31st of March. 6. See how instruction has further extension of the scheme. Where Mr. Rai Botaku, Standing Council, Agriculture University, submits that the university will agency for implementation of the scheme. Submits that unless the funds are released, petitioner's retention cannot be on the funds available with the, cannot be funds from the agriculture university. So, such circumstances, there no instruction by city affidavit, so that by the this matter immediately after the next date fixed, interim orders passed earlier. It is however made clear that the salary remuneration, salary/remuneration, the petitioners payable shall be from the funds are available and dispersed by the that metrological Indian
Metropolitan Department.
Indian metrological.
Also, funds are, as per my instruction, funds are there till 31st March.
Till 31st. 31st is expiring tomorrow. So,
Fine. People got to honest, any metal.
issue notice here. So retirement. So who's for the respondent department? The resources. Right. Respondents. 7. No, sorry. 5.
7.
7 and 8.
8.
Market Talukdar APS.
And 9 also.
Huh?
7, 8, 9, 9 also.
You appear for 8 also.
8 also.
7, 8, 9.
Sorry, lots of 8. Finance department.
Since the respondents are represented. Their instructions and file necessary affidavit to advise them.
By the
Transfer. Of the lordship, the policy on transfer.
Who's for the respondents? Who's the CGC? CGC. Heard. Mr. Who's the last CGC? SK Medi.
Yes.
Mr. SK Medi, let's see. Where is the impugned order of transfer?
Lordship at page 27, lordship. In respect of petitioner, serial number 4.
Petitioner is aggrieved by the summer chain transfer order dated 24. Is it a summer chain?
Lordship.
Summer chain transfer order dated 24/12/2025.
And subsequent order, lordship.
Petitioner's name is
At serial number 4.
4. Where the petitioner's name is shown at serial number 4. Is transferred from present place of posting at
175 battalion to 226 battalion.
and posted at 6 battalion, which is posted in
Lordship, now 175 battalion Gauhati and 226 battalion at Sukma.
Huh?
Sukma, Chhattisgarh.
then posted to Sukma, Chhattisgarh. So, petitioner claims to be the caregiver of ailing wife, requires constant medical care and supervision. She so person with
100%
benchmark
disability.
disability, suffering having 90% permanent disability due to paraplegia, following a pelvic bone. Petitioner represented against the transfer, which House was to rejected by order dated 10/6. Council for the petition submits that in terms of the standing order 04/2022 dated 27th of September 2022, the petitioner being a caregiver, disabled person, is exempted from the transfer. But stop the agreement. Transfer orders were to be made effective. Mr. Bidaka, appearing on behalf of submits that these government orders which were made effective from 1st of April has been deferred till 15th of May 2026 because of the ensuing assembly elections. That view of the matter, that the matter will be stayed again after 4 weeks. Each time the respondents will file complete their instructions and file necessary affidavit. Prayer for interim, if any, can be renewed by the council for the petitioner on the next return.
Apply that. Okay. Lordship has rejected,
Is appearing on whose behalf?
Bideka. CGC Bideka.
Bidaka. Yes. Bidaka. Say very loud. See Bidaka.
Lordship, the engaged counsel for item 18 is in court number 1. That the matter
We
taken
cannot
up
help you.
after some.
We cannot help you. How many CGCs are there? Only Bidaka. He is the only CGC in Gauhati High Court.
No.
Then That is the reason why CGCs, so many CGCs and government advocates are there.
Yes.
If he is not available, he has to make arrangements. Yes, what is your problem?
That petitioner initially appointed, enrolled as some rifles, one member. But he was telling here, he was unfit.
You came to court.
Yes,
Court directed you and you were found fit.
yes.
Then again you were found
Again-
unfit. But defense personnel will have to undergo medical supervision,
Yes, that
medical
is their-
review.
So how to direct the respondents to
Where is the first, where is the review? Or after the court's order?
yes, yes, my lord, 52 months.
52. That's Constitution, then
Subsequent, there are
after the High Court's order, where is the medical board?
yes, this is the medical. board.
This is the medical board after High Court order.
After second round of medical. Please tell me, my lord, two round of medical.
Ah,
Please tell if it was declared unfit, he approached the court, direct the respondents. At the time is 39 times.
right.
First you is 39. He was declared unfit or medical incapacity and overage.
Then he came again.
Again, in my lord, and
Then
the direction kindly see, my lord.
that's okay. Direction was to go for review.
Review and if found fit, should
Ah.
be, my lord.
Where is the review medical report after
Yes,
the second
yes.
order?
After second order, case 48.
48.
No, 52, my lord.
52.
The medical board, my lord,
Ah.
and report is kindly see, my lord.
You are found to be with hypertension. 53.
But he was declared fit for NXD. This was the initial medical commission.
Then
Then again, my lord, kindly see page 56. Again, petitioner was called after about 2 months. Direction was that found fit, my lord, continue in service. Thereafter, they can do my lord. But petitioner never allowed to join my lord. Also filed contempt petition that was closed, my lord, saying that
comes parties issue notice returnable for it's Mr. Bideka.
Yes.
Learned CPC. Accept notice on behalf of respondent. Based after the returnable date.
public.
Yes.
My lord, here, my lord, the petitioners are masterful employee, my lord. He approached the nursing for pension benefit. Similar matter, my lord, on Friday, your lordship should notice, my lord.
Raise your claim during service period that you should be regularized.
My lord, what happened, my lord? They approached the Honorable High Court, and the Honorable High Court allowed them to pay fixed pay. Accordingly, the fixed pay was granted by the state, my lord, and kindly come to annexure 3, my lord. By this, my lord, the fixed pay was enhanced. Thereafter, they went on superannuation on 10th of October 2025. My lord, the basis of good judgment, and there is also one circular also of 2003, my lord. Let the notice be issued, my lord. Let them
Where
respond.
is your order of regularization?
I,
Yeah, sorry. Appointment orders are here.
and Master, they are not such appointment letter has been issued, my lord. Only relevant is annexure 1 at page 18. At serial number 1, my lord, annexure 1, the petitioner number 1, my lord, we has been working from 1/4/1987. And serial number 16, my lord, the petitioner number 2, my lord, is working from 1/4/85. And there, he also approached the Honorable High Court at annexure 2, my lord, and kindly peruse their enhancement order, which is at page 28, annexure 3, my lord.
We'll issue notice.
My lord.
But PTC
4, 5, and 6.
4, 5, and 6. It's for forest. Mr. I bought a rule here. Small one. Sharma will spot in 7. Small. If next of office be furnished.
Problem.
The case was initially filed one repetition, madam. Was withdrawn, madam. That was the case of constable advertisement. So caste certificate, madam, a non-criminal certificate issued subsequently. That matter has been fixed tomorrow. Tomorrow, yes. 6/5, I have challenged the 6/5 at the clause of the advertisement.
Let it come tomorrow.
Yes,
Along with WPC,
555/26.
5 of big 26. Tomorrow for what? For admission?
For final order, procedural of that BRI.
For final orders?
Yes.
That series of matters?
Yes,
Familiar?
familiar. Otherwise, caste certificate issued earlier, madam, prior to date.
Yes.
Applied for constable in Central Armed Police Forces. Qualified all-rounder notice without issued by SCC. So Lord Sir, kindly turn to page number 7. He was to be considered against general area category economic section. For the state of Assam, there were 59 vacancies notified, but only 2 filled up. 57 has not been filled up. He qualified in the case for the
Any instructions at this stage?
No, Lord Sir. Notice may be issued.
Heard Lieutenant Counsel for Parliament should not. Correct. Mr. Kopi Victor is within a period of 1 week. This matter again. After the
Look.
The Basachula village. Now, thereafter that order was not set aside with the appellate authority. on the ground, my lord, that the private respondent who secured 2 marks lesser than me ought to have been given, my lord, 10 marks against preference, man. Now, there is no provision for giving marks against preference. It's only, my lord, when 2 people are equal, my lord, preference can be given.
Where is the advertisement?
Advertisement, lots to find page 20. The conditions, my lord, are there in page 21. This is the type copy, my lord. Serial number, my lord, 5, my lord. In the matter of appointment of Gaon Pradhan, the claim of family of late Gaon Pradhan will get preference and views the Muzadar are to be taken into consideration. Now, my lord, I got, my lord, 20, my lord, 26, 28 marks, my lord, and he got 26 marks. Then we evident from the impugn order.
Where is the impugn order?
Impugn order that starts at page 64, my lord. And, my lord, the marking, my lord, has been referred in page 67. I am, my lord, Nipen Kumar Nath, my lord. I got 28.67. And Kusum Kumar Nath, my lord, was the appellant there. But he got 26.67. Now, the appellate authority says, my lord, that he ought to have been given 10 marks against, my lord, preference. Whereas there is no provision, my lord. I have quoted the rules also, my lord. The 162 rules of the executive instructions to the rules of, my lord, under the Assam Land and Revenue Regulation. Page 13, my lord, I have 12, I have quoted the rules. 5, my lord, is the 162, 5 is the preference portion. Preference shall be given, page 13, my lord. Preference shall be given to the family members of Gaon Pradhans and views the Muzada shall be taken into consideration. So it talks about preference, my lord. And preference comes, my lord, when, my lord, people are equal. Had they got equal marks, the question of preference should have come. There's also a judgment of our honorable court, my lord, it says that preference, preference is to be given only when, my lord, everything is equal. He had taken some other grounds, the appellant had taken some other grounds, those were all rejected. Only point is that, my lord, he ought to have been given, my lord, 10 marks more. And accordingly, my appointment, etc., has all been set aside, my lord.
Against the appeal order, my lord, review is reply.
It is there, my lord, but
D.
that is there, my lord.
But if you should have a review,
But now this election times, my lord, this is violation of fundamental right, my lord. Without serving this order, my lord, my appointment has been, my lord, cancelled, and another person has been given charge. So I'm praying for a stay of this, my lord. Otherwise, my lord, this person, my lord, who has been,
Where is the impugn order?
my lord, page 60, my lord, 60, my lord, 3-4, my lord, it starts. And the grounds are given, my lord, in page from, my lord,
It says the appeal is admitted.
no, this, my lord, this dispose of, my lord.
Huh?
Dispose of.
page 64.
Page 64, it starts, my lord. Page 67, my lord.
68. 68 is the order.
Yes, my lord.
Yes.
Selection and appointment of respondent number 4 as Gaon Bora, my lord, is hereby set aside and quashed with immediate effect. The district commissioner is directed to appoint the appellant, Kusum Kumar Nath, to be to the post subject to verification. Thereafter, my lord, page 69, the district commissioner has passed an order. Now, this order was not served upon me, my lord. 10, my lord, annexure 10, my lord, the district commissioner passes an order, my lord, appointing, my lord, the respondent number 5, my lord, who is the appellant there, and I have been terminated, my lord. And page 70, the circle officer headed over charge to him. Whereas there's no provision at all for, my lord, giving any preference marks to anyone. The rules are very clear. The advertisement is very clear. It's only preference. The member of a family of the government.
That's why there is a provision for review, my lord. He can agitate it before the review, whichever.
Now, the election times, my lord, they are not
why
entertaining
review
anything, my lord.
provision is there?
In fact, my lord,
Yes, if there is a wrong, my lord, they will look after by the review.
in fact, my lord,
Definitely, my
every
lord.
time they have to
Send
come
it
for
to
a
the review,
discussion
my
or
lord.
review.
Let
Then,
them
my lord,
file a
have to come
review.
second time, they will challenge the order of review, my lord. No, this has been happening, my lord.
Maybe it's a procedure.
Then these are election times, my lord. They will not ever touch this review for months, my lord. Now.
There is a judgment, is one judgment of this court defining what, when is preference to be.
Yes, my lord. Yes, my lord. I have it.
Has to be given where there is a equal mark.
Was there equal marks?
Equal marks. No, then wala preference will come.
Was there equal marks between the petitioner and respondent?
Not equal marks.
Paragraph 12, my lord.
There is an earlier order to that. It's an earlier order to this.
No, I got this one. Here, my lord, the appellate authority himself, my lord, found that I got 2 marks higher. That's part of the record. And he says that 10 marks ought to have been given. There is no provision of not giving marks at all.
You don't have the earlier judgment.
No, my lord, I did not get it. Got this one.
But Mr. M. Dr. Leonard comes with the petitioner, Mr. Suti Alana, additional city government advocate appearing respondents number. Mr. S. Dr. appears respondent. Says the waived extra copies be furnished within steps of respondent 5 by speed post with 1 victim. Additional agreed. 6 passed by the Director of Land Records and Service, the appellate authority. By the respondent.
Respondent. Respondent
Respondent number 5,
5.
challenging the order of appointment of the dedication issued by the deputy for being appointed as a governor. Which village?
Bassa Suba, my lord, Gaon, my lord. Bassa Suba village. BASSCHU.
Now Pradhan for the village Basa Chuba,
Lot number 3.
Lograi lot number 3 under Sipadhar Revenue Circle, Assam. Council for the petitioner submits that by the speaking order passed by the appellate authority, his appointment as a Gaon Pradhan for the state made with on the ground that the deputy commissioner failed to award preferential marks to the appellant as the appellant was a relative of former Gaon Pradhan, which is contrary to the executive instructions and selection norms. So, submits that the advertisement that indicating preference cases of the relatives being Gaon Pradhan against candidates concerned, Kumar. There is no provision for allotment of any marks. So it further submits that preference, the parameters of preference are to be applied only when marks obtained by the competing parties are found to be equal. Submits that in the present case, the petitioner had secured how much marks?
28.7, madam.
28.7 as opposed to the marks 28.67
Sorry, 6, and he got 26.6.
as compared to mark received by the private respondent as 26.67. So under such circumstances, there is no scope for applying the parameters of preference and the same has been wrongly applied by being agreed with the petitioner by Para. Counsel for the petitioner has pressed into service judgment of a coordinate bench rendered in so and so basis so and so reported in support of its content. The respondent counsel submits that an stage notice be issued permitting them to complete their instructions. They are considering the submissions made. And they have raised the question of maintainability as there is a provision for review under executive instructions 164C or D.
162D.
162D, which provides for a review and which has not been available by the petitioner. Considering the issues raised, let me this issue return to fix since it's one to steps on respondent 5 by speed post. Same date. Switch to the orders passed by the appellate authority. Deputy Commissioner has also issued the constitutional order terminating the service of the petitioner and charging the arbitration. Circle officer.
No, he has been handed over the respondent 5.
Respondent. Nine. Prayer for interim will be considered on the next return of the bill. It's on 29th of April.
Okay.
The petitioners are basically aggrieved by the fact that they have been serving under the board, that is Assam State Agriculture Marketing Board, and for quite some time, they have not received their salary for 11 months. In a similarly placed case, your lordship has gone through the similar cause of actions, and the lordship has also protected the petitioners in those institutions pertaining to the fact that a fund was kept intact in the accounts of the ASMP, and the lordship has directed that may not be diverted and it shall be used only for the purpose of disbursing the salaries of the income. Now, my lord, I may be allowed to produce the copy of that order, my lord, passed with that earlier. Alone.
Regarding it, we have already communicated to the finance department. Still, we did. There is a cabinet decision.
In between, my lord, yes. Kindly lordship may come to order dated 21/11/2025. I have given 2 orders, my lord. The subsequent order is very important. After hearing us, my lord, in that petition, your lordship has given this protection till the next date fixed amount earmarked for area salary shall not be disbursed for any other purposes without a leave of this court. Now, my lord, that petition continued as such, my lord, and my learned friend appearing for the ASMB authority have also filed affidavit, my lord. They have not disputed to the claim in that petition and also have admitted that they are area salaries and have also given assurances that they will be paying the salaries, my lord. They are making the process to pay the salaries, my lord. Now, in between, what happened, my lord, recently again, when this court had put a query upon them that before 31st March, if that fund is not utilized, that fund may get debts, my lord. So the court has given a very important order in which, my lord, in those cases, my lord, the court has given a direction that they will create a separate account for those petitioners, and the amount they are entitled to receive will be kept intact in the separate account, and they will pay from the separate account, my lord. Kindly, lord, I have that order, my
I
lord.
have not understood what is your problem. You are claiming your salary.
Yes, my lord.
money is there in the account,
Yes, madam.
not dispersed. Why are you worried about putting in this account, that account, going back? How is it relevant?
Madam,
If you are entitled to salary, the amount is there in the salary, you are duty bound to pay it.
yes, madam. Then I humbly submit, my lord, my lord, may pass a similar order which has been passed.
Madam, what similar order? First, allow us to understand what is the problem.
Yes, madam.
Why this amount has not been released for salary?
Because also there are cabinet decision. My instruction,
What is the cabinet decision?
cabinet decision. I am also annexed that document, my lord. That is not the cabinet decision. This is the cabinet decision.
What does it say?
Cabinet decision says that for what happened also in the assignment of extra marketing group, earlier we paid the salary from our own source, but due to the commencement of GST, the collection of sales has been stopped. Accordingly, the government cabinet have taken decision to give VRS to the employees, but these employees have not taken the VRS of the VRS. After that, they know that the financial condition of the board loss. Then the state cabinet decided that it regarding these employees, it was further directed that the agriculture department to decide on the continuation of these 136 employees. If agriculture department can arrange for making payment of salaries of those employees from their available source, the department may utilize their services appropriately. Otherwise, the department shall consider closure of ASMB completely by giving various those 136 employees also. That is the decision.
What have you done now?
That decision already have not taken by the agriculture department. But there is a aforesaid being granted for which the board says clarification from the finance department. But regarding the aforesaid,
You have been given liberty to close.
that decision have been taken by the agriculture department, not from the board. Finance department.
So why have you not released their salaries?
Because the cabinet decision is something different. I have that less this order communication that is 6 March 2026. We have stated that now an amount.
That amount which is at the disposal of the board is to be disbursed for what? Only VRS.
There are separate. There are head is it. The outstanding regular monthly salary, employees provident fund, etc. Leave encashment and gratuity, etc.
For who?
For
the employees.
Employees.
This is what they are claiming.
We have already released 10.24 lakhs was the outstanding abuse, namely leave encashment, gratuity, and normally retired employees. It includes retired the employees who are retired normally after the cabinet decision.
How many employees are there now?
Right now, 136.
136.
And in between also, we have released the salary for 6 months from the month of September release.
Now these 136 employees, you have no money to pay.
Yes, we have no money.
Why are you not closing it?
Their decision have to take by the government laws, not from the board laws. It is the cabinet decision. Till then, they have not challenged the cabinet decision. On last 26 March, also we have released 1 month salary. The employees.
Now, what is this amount used for? This 9 crore something is
95 lakhs.
What is that?
We have communicated the finance for clarification. Because Lofty authorized not to disburse the amount that is
For any other purposes.
for any other purpose from the without
salary
leave of the case 131.
This amount has been released for what purpose?
Firstly, regarding the employee provident fund, outstanding a regular monthly salary, leave encashment, gratuity, etc.
Then why are you not
Also,
using
we
it?
have already released them 6 months salary.
Maybe, but why not the rest of the amount?
This of them also it is not sufficient to release the entire salary.
You release it on pro rata basis.
On
Who's stopping
26 now we have released 1 month salary. We release their salary for
So you're
1
not
month.
doing them a favor by releasing 1 month, 2 month salary. You are engaging them in service. They're entitled to be release their salaries. What do you mean you are giving them?
Regarding
You're doling out what? Some charity. Then
clarification from the financial
what
requirement.
clarification? You see your instructions which you have given to me on 6th of March. You have a copy of this 6th of March. Read the first paragraph.
With reference to the subject cited, I have the honor to inform you that the ASMB received an amount of 24 under the head of account from the Government of Assam for payment of outstanding at regular monthly salary, etc. Second, the employee provident fund, etc. Leave encashment and guess asset of under establishment expenditure.
So you have utilized 10 crores
10 crores
out of
only,
that. Now a balance of 9 crores is lying there. This amount is only for this one.
Next balance. Now an amount of 9.75 is lying unutilized in the bank account of the SMP. This connection is maybe brought to your kind notice that the honorable cabinet in that meeting on dated 26/11/2024 directed the agriculture department to decide on the continuation of the 136 employees who have not opted for VS. If agriculture department can arrange for making payment of
Let
salaries.
the agriculture department arrange. Until the agriculture department arrange, what are they supposed to do?
From their own source, but not from the payment
You have
of salaries
received-
of those employees.
Mr. Council, you have received these 20 crores for only these three purposes. Yes or no?
Yes, sir.
Yes. Now you have disbursed 10 crores. Why are you holding on to the other crores and sending letters here and there asking for clarification? You have received this amount for that purpose. You release that amount.
That we have to take instruction.
What instructions you want? Why do you want instructions? It is clear from your letter that you have you have received this amount for outstanding leave encashment and employees provident fund. Out of the 10 crores you have released, did you receive any instructions while disbursing 10 crores? Did you ask for instructions? No. Now for the balance amount, why are you asking for instructions? Why are you refusing to release this amount?
So we are not filling those. We have already paid them 6 months salary.
How many months salary is required to be paid now?
11 months.
Not 11
11.
months.
The current petition I have given the list, my lord.
That list has been prepared by himself.
From the records, my lord.
For which I have to take instruction. Based on that, how many?
No, what instructions you want? We don't understand. This communication you have sent to the finance department is that there are 3 grounds on which you have received this amount for 3 purposes. You have released 10 crores out of that 10 crores or now for the balance amount you are asking for instructions. Why? Why?
Because 9.7 is not sufficient. So my
If it is not sufficient, then we disburse on pro rata basis.
I have to take instruction. Because if yes, 81 they prepared a list. So we have to take instruction.
Take instructions, come back on Friday or Thursday. Thursday, take instructions.
May I just take one order, my lord? Very one of my learned friend on the same issue, if the lawsuit is correctly correctly said, my lord observed, have also said, my lord, on the last occasion that they were arranging funds, and because of this, my lord, this court has passed this order. Just one moment, I'll just take this order, my lord. It's very important, my lord.
I'll take out.
It's very important, my lord.
The board is supposed to provide for its own finance.
My lord, that's it. And
It is supposed to raise its own money.
yes, my lord.
Now, what is the revenue?
My lord, the revenue earning sources, my lord, they are free to take a call, my lord, but the pending amount which
You are an employee of the board.
Yes, my lord.
Are you not aware what are the sources of income for revenue for the board?
my lord, from various sources they have input.
What is the source? As an employee of the board,
Yes, my lord.
you are not aware. What are the sources of income for
They
the board?
collect, usually they were collecting cess, my lord, which my
Then-
learned friend is saying, but
then
due
what
to the
happened?
GST, my lord, the cess has been removed as what my learned
So
friend said.
what are the other sources available?
My procurement makes through, my lord, eddies and everything, the tender they float, my lord.
You show us that what is the revenue.
And
earned.
I'll show, my lord. But
What
kindly,
is
lord,
this? What is this order?
yes, my lord, kindly see, my lord, and 7.3, my lord, paragraph number 2, my lord, my learned friend was submitting on the last occasion. Appearing for respondent submitted, board has already approached the finance department praying for a clarification with regard to the manner in which the utilization amount of rupees 9 crore available with them in their accounts would be permissible to be made in view of the decision by the cabinet on 26/11. Now, my lord, next paragraph is very important. So and so, my lord, submits that amount would lapse on so and so 31st and accordingly prays for appropriate order to be passed by this court was protecting the interest of petitioner herein. As Mr. So and so has submitted that the process has been initiated for receiving clarification with regards to utilization of the said amount lying in the account of the board, the court directs, my lord, very important, an amount of rupees 17 lakhs, my lord, which was their salary, being the area salary receivable by the petitioner with effect from May 2025 to February, be kept in a different interest-bearing account until, my lord, until
What is
further.
the amount of salary that you likely to receive.
Yes, ma'am. Here I have given a chart. My lords may kindly come to page 81, my lord. 81. 81, I have given a, my lord, a list of all the petitioners, and the total amount due against them is, my lord, 3 crores 55 lakhs and some odd, my lord, at page 82. So this is the amount for the current petitioners, my lord. But by tomorrow, that is 31st March, my lord, if the fund access, then my learned friend will come with her instruction that the fund has lapsed, my lord, after 31st March, my lord. So this is my humble submission, my lord, that, my lord, that my learned friend bring instruction, my lord. Till then, my lord, some protection may be given to the petitioners, my lord.
There is no senior signature.
No, no, this has been, they can verify. If
They have to
they,
verify.
if they do not agree, my lord, they can verify. And I have given from page 83 the list of, my lord, all the petitioners whose salaries are due, my lord, from 83 to page number 127, my lord. My lord, they have been working for last 11 months, my lord. They are paying in peanuts, my lord. And they are saying that if any clarification, finance department, my lord. It was under the budgetary allocation. The fund was allocated for paying our salaries, my lord. It is lying in their account, my lord. And tomorrow this fund may get left, my lord. That is the only apprehension.
Yes.
Yes, if there is no senior signature, I have to take instruction for.
You take instructions, but
On
what happens
Arbitration.
if the fund lapses? What happens if the fund lapses? What instructions do you want to take?
Then the amount which has been utilized, non-utilized, is being different.
In the earlier order, where it was directed to be kept in an interest-bearing account, has it been done?
My lord, he on the again.
Yes, sir, that has been done.
That has been done. So you transfer this amount to the same account.
Also, the amount which has been next by my learned friend, we have to examine that.
You examine it, but meanwhile you transfer this amount.
Yes, ma'am.
That is such I have taken.
Huh?
To have 2 I have to take instruction.
What? At 2.
Or have been.
No, at 2.
My lord,
2 p.m.
I'm obliged, my lord. Highly obliged.
So let me.
Yeah, transfer order. Connected transfer order has been already stayed, my lord, so which I have annexed on page 29.
Oh, every transfer order is different on the facts of the case.
Yes,
You
ma'am.
tell us
See,
what are your
I have
facts?
assigned this transfer order on 2 counts, my lordship. The first count is the clause 3(1) and 3 Roman 2 of the guidelines has not been followed, my lord.
What
I
is the
have been
guideline?
there in 3 years,
You
my
are
lord.
posted where?
Sunai education block. Sunai education block and
Chennai.
the Kasar
You are posted as what?
is the block element.
Block elementary.
3 years has not.
Why these are all education matters, is it? Why is it coming to this bench? When was the transfer order issued?
My lordship, impugn order is on first on 15th March.
15 March.
Thereafter,
This is an education matter.
yes. Kindly see, my lordship, page 29 maybe. Because this is the place where I have been posted. So that order has been already stayed, my lord.
So let it be before the education bench. This matter appears to be a matter covered by civil, pertaining to civil bench 2. Under such circumstances, registry to examine the matter and place it before the appropriate bench by tomorrow, considering the urgency expressed by the writ petitioner.
The order date is 21/3/2025. The expired, so we have communicated the order and the letter for other proceed the case, but there is no that from the I leave it to know. This application has perhaps awaited because my lord may kindly see the order dated 25/10/24, wherein they had come up and said that he has already passed. But there is already an order of 24.
Service matter.
No, my lord, section 11 applies.
They are contract employees under the
Yes, sir.
department.
Yes,
And they were terminated, therefore they are filing in
yes, they have come back.
arbitration. There are several other matters.
Yes, but only the
Only in
most of-
this matter, the petitioner expired.
Fine.
That, spite of the steps taken by the government. See. Taking this steps. Considering time that has elapsed since the date. That would be time of life is for the response.
Well, much of.
Let me bring up some report.
Yeah, apologies for this matter. I have skipped certain records, not the entire record. I have also taken an order of this court. Matters that is put by this honorable court lordship. Well, lordship, they prayed for a special medical board to be constituted. They will appear and then they will provide all details.
But here is a case, we only wanted to, how many vacancies are there?
That lordship, I cannot.
Well, only
Okay,
last
that-
order,
Lordship, that
only one post has been filled up.
Our department was etc. and quality for this. There is vacancy.
4 vacancies.
Five of these posts were reserved for the, can you answer both? Reserved for the. Our department. There are some other department also, they are also major party respondent here, Panchayat and Rural Development.
They have filed an IA for impeding there. This IA is not focused there.
Why is this for orders today?
Lordship for that IA, Lordship, since it is pending.
IA, what is that IA for?
Lordship, IA is for
Impeding PNRD.
PNRD as a party.
Party respondent.
Why PNRD?
That I for reserving those posts for lordship, that is an including period.
PNRD. You are representing who?
I am Corporation Department. They have made us party because they are selected Corporation Department as well as the PNRD Department. For our department, I have submitted my lot. PNRD, they have included PNRD as a party responsible, but
Lordship, the IA number is 3307. Lordship, may kindly take up that our prayer is for the interlocutory order for keeping one post vacant for this, not for implement. Implement is also already done. Lordship.
Happened to the writ appeal which was filed?
Lordship, that is pending, Lordship. Notices were issued, Lordship. And on 30th of April, that petition has been, writ appeal has been filed. Lordship, similar matter came up before the Honorable Court this morning at 18, Lordship. Those petitions were fixed after disposal of the writ appeal. Since, Lordship, the issue involved.
There is a coordinate bench order where it says that the second medical review, medical evaluation, there is no restraint on that. That an appeal is pending. You are raising the same issue.
No, Lordship. But in this appeal, Lordship, they are challenging the process only. So we are agreeing to this process, Lordship. We have agreed to the process, Lordship. We have gone for the examination, Lordship. Their benchmark percentage is different, Lordship. We have gone personally, Lordship, and then our benchmark is approved, Lordship.
You are only asking for the records.
Yes, Lordship, on previous 2 days already, Lordship, gone where medical relevant documents were asked for.
Hearing this matter, Lordship, they are challenging the outcome of the medical board, Lordship. And the writ appeal is also, Lordship, similar. There also, the outcome of the medical board.
Writ appeal is on the aspect of the process being undertaken.
Yes, but they agree.
The writ petition, coordinate bench writ petition has agreed, has held it, dismissed the writ petitions to say that there is no bar.
Yes.
Relying on the judgment, some judgment.
Yes, yes.
Against that, an appeal is there. Here is, he wants to know the results. He wants to see the results. You're not giving him the results.
Lordship, then there is a similar order. Lordship, I can place him a copy.
But why are you holding on to the results? What is the secrecy of the results?
The results are already declared, Lordship.
No, the process by which you have undertaken the examination, they are being found to be 57% disabled, and you are reducing them to 23%. How the process has been undertaken?
Lordship, in that case, Lordship, I can get the entire medical board, Lordship, result outcome.
That is what you are supposed to do.
Yes, Lordship. That, Lordship.
One after the other, you have been given time and you are deferring and deferring on producing this result.
See last one.
Why? 9-3 was the last order. You were supposed to wait for time, for 1 week's time to produce the report.
Lordship, the report, Lordship, I can give, Lordship, next week any day. Basically, the joint director records are also essential, Lordship. That I am unable to get, Lordship. But from the principal, Lordship, I can get it, Lordship, on Monday or Tuesday, Lordship. The reports of this particular candidate, Lordship.
No, only the report will not do. The question is
How
they have been,
yes, Lordship, and they are
found to be below the benchmark disability.
Everything, Lordship, I'll get.
The last one even so then we will take the admission for final disposal.
Final disposal, then it will have to be after the vacation. Third counsel for parties, the respondents, medical, the health departments, standing counsel, Mr. D. Bowman undertakes to We are recording your
Yes.
submission. Undertakes to produce the relevant records, but medical records pertaining to the evaluation, medical evaluation of the writ petition.
By the lordship respondent number 30.
Medical records for the writ petitioner's evaluation, respect of the disability, percentage of disability. Stop. According to the writ petitioner, he was declared to be a person having 57% disability by the district authorities, whereas the respondent health department has, on re-evaluation, has down the disability to 23%. Next, the process undertaken by the respondent will sail in the present evaluation. Stop. Something has changed, but relevant. Yet the bit of notice. Yes. So, and the process undertaken to the re-evaluation of health department percentage of that these records be placed before the court. List accordingly.
Last one.
We'll pass orders.
7.10
77, and the for 10 and 11. I'll get out of board. 7, 8, and 9. Mr. B. Chaudhary for
13.
Public.
Lazima को छोड़ा देते 9-3 अभी जब तक respondent
take substituted service by publication.
but Lazima को छोड़ा you have been served.
If you have been charged, refused,
Yes.
returned. Take substituted by publication. Third parties. 6. The steps undertaken by registered post. And registered post.
Yes.
Registered post was returned back with the endorsement within refused or returned to sender. So N Parameshwaran submits that team service has to be pursued. And it's an application under section 11(6). In addition to the endorsement of petition of service, petitioners directed to take steps by publication in dailies, sufficient circulation. Statements that namely one action is bill daily and the commissioner will take steps as directed and file affidavit in compliance date is after 4 weeks.
Public.
Yes, compliant.
Classification.
Child department respondents. You are appearing for
Yes, Gautam.
S.
Gautam.
So, yes, respondents are there. Right. Unrepresented. Purely in the interest of justice, that is then record still on 2nd of April. In which state, if steps are not taken to comply with the order, dated so and so, passed in the pieces so and so, consequential order passed with. Instead of 26.
Thank you.
Five years, 5 years. So whom are respondent will not be appeared.
You have filed your rejoinder. Want to file your rejoinder?
Statement.
Reading the bit exchange the matter except 6. Still for admission. DJ does for the response.
My lord, I am for the first wife, that is respondent number 8.
Just file the IA.
Yes, Mr. I has been filed by the institutional lordship with the second wife having on minor side. Now, Lordship, she is denying to share the.
Have you read the full bench judgment?
Yes, Lordship.
You have.
Yes, Lordship.
So what is the direction? What is the ratio laid down in the full bench?
Hold on, there is no ratio. Lordship.
There is no ratio. Para 23.
Yes, Lordship. That 22, Lordship.
23.
Yes. We also provide that in the event of any such other person who are entitled to the benefits of the family pension in terms of the Rule 143 of the pension rules, including the second or furtherwise, in a case where the parties are governed by the Mohammedan law and not appropriately maintained by the eldest and servant to the wife to whom the pension would be paid, the remedy hereof would be to make a claim for maintenance in appropriate from under law and not a claim for payment of family pension by the state authority directly to such person. But however, if in a given case the state authorities on their own volition are of the view that under an acceptable circumstances, the authorities are agreeable or required to pay the pension separately to any such member of a family of a deceased employee, this judgment may not constitute to be an absolute bar on such separate payment. Now, Lordship, here is acceptable circumstances, Lordship, because Lordship, at this stage, after receiving the family pension, Lordship,
The para 23
yes,
makes it very clear
yes,
that your claim will lie only for maintenance.
yes.
And the department on its own volition may do so.
But Lordship, under acceptable circumstances,
We are not agreeing with that in terms of this one. But then it comes for the
Lordship,
petitioner.
another thing, Lordship. I will file, Lordship, I will approve.
We don't know what you filed. We are going by the mandate of the full bench.
But Lordship, till that, Lordship, otherwise, Lordship, the petitioner will suffer loss, Lordship. She has said.
You have a remedy, you have a forum. Go there, file it. There can be no direction from the.
Admittedly, the petitioner
You are
is
a
the second
second
wife.
wife. You are a second wife.
Yes, Lordship.
Under what, under the provisions of pension show us that you are entitled to pension.
As per full bench judgment,
As
Lordship.
per full bench judgment
Yes,
is a
Lordship.
provision made for other wives under the Mohammedan law.
Yes, Lordship. It is more than Lordship.
That's right. But
The
there is no direction.
The
You
petitioners are
you show from full bench that there is a direction issued to the respondents.
the deceased employee is governed by the Mohammedan law.
Right.
Paragraph 15 and 16, Lordship. Dear Lordship, she is entitled.
She's entitled, you go and make your claims. Your entitlement under the Mohammedan law and your entitlement towards pension are two different things. Pension is governed by the pension rules. Pension rules does not give any provision for release to other further wives.
But Lordship, as
Your
per
claim in the Mohammedan law, you have to follow it, you have to pursue it to an appropriate forum.
yes, Lordship, but in paragraph 16, it is made clear, Lordship, under rule 143(1) of the pension rule of this, be entitled to the benefits of family pension, Lordship. She, second wife is entitled, Lordship.
Entitled, but subject to the same being released. To
Not-
release it.
But Lordship, nothing has been released for her family, and she is not sharing any amount. But I am entitled, Lordship, and second wife, Lordship. Moreover, Lordship, one after another, Lordship, they are making false statement before this honorable court, denying that I am not second. Moreover, they have filed. She has filed on title suit, Lordship, before the junior division, Lordship, Barbata, disputing my marriage, Lordship. But from the evidence, Lordship, from the record, Lordship, I have annexed, Lordship, in my.
We can't pass any orders. Tell us that there is some other authority over and above the full bench
No, Lordship.
or some provision which has not been construed properly. We'll consider it, but once the full bench has rendered a judgment, very clear, he explained exactly the position.
By this entitled, Lordship.
We are not saying that you are not entitled. Your entitlement as a second wife under the promotional law is one aspect, is one compartment. And your in the claim for the entitlement to be decided by the authorities under the pension rules is another, because pension rules talks about disbursement of pension only to one legal heir, only to one wife. Your claim in respect of your share of pension from the first wife has to be urged in a different court. This judgment is not an authority for that. And this we cannot, because the was from the roots of pension that it is
Yes, sir.
permissible.
Spiral, there is no provision.
Then you have to challenge the rules.
No,
Then
but Lordship, second
can
wife,
we direct the authorities to something which is divorce the rules?
but Lordship, as per prudent judgment, Lordship, here is a right of 23%.
Learned counsel
Last-
for the petitioner, the petition second wife. Late. Islam, who was serving as a what?
Inspector of Police.
Inspector of police. He died in harness or later, after superannuation.
After
Subsequently, the late husband superannuated from service and was granted pension by the PPO so and so, para number 3, and he has been receiving pension. The petitioner married to the Islam. And Islam as the first wife, who is respondent number 8. The marriage between the petitioner and late Islam, one son, one male child is born. Submission of the council to the petitioner that Islam, that the petitioner is one of the wives of late Islam, and out of the marriage, male child, therefore, male child, and the petitioner. That's why, and the family pension. Has case certificate. So, better. Name of respondent 8 is not here. Page 21. Respondent 8 is shown as serial number 1, and the petitioner is shown as serial, and the other sons and daughters are also listed there. So, under such circumstances, the petitioner is to the court agreed that the respondent authorities have declined to release pension paid, share of pension paid, share of family pension payable. Pursuant to issuance of notice, the respondents have filed the private respondent What do you say?
Lord, I am housewife. For my lord, this rule is concerned. My lord, mine, mine.
You have to refer it from a judgment. It's available in the book. And we read it from a judgment.
Here is the. Then according to this housewife already got that. Without any permission, without consent.
Private is important. This book for claim to the second marriage during the lifetime. Husband is prohibited from entering into second marriage during the lifetime. Where the conduct which prohibits second marriage. Second marriage. That
That
council appearing to the accountant. Retired government officer, namely late. It's clearly mentioned. See the statement mentioned. State council of the person whose name is reflected in the pension proposal. Second way. Pension from pension. Specifying. that is the main right. So, lifetime spouse. Spouses. Pension or a part of the state. Disbursement by the government. Pension has to be there can be no variation. If if we benefits second wife. Right? Segregation of the pension. Can be dismissed about it. I filed in the accompanying contempt case. Sent by Mr. Steady. Such a contempt. Prayer made in the eyes. The contempt. In the eye. About the withdrawal of the paragraph number. Party number. Raj Sharma. Submitted that. I filed for seeking correction. The order dated 13/2026. In IS 347 of 26. I said I prayer was additional child and time. I said I the applicant sought to be Kalyan Chakraborty. Additional chief secretary. Child and will development. Time. School 6. While disposing of the I 7 of 26 by order dated 13/2026. Name mention 0. As the officers of to be needed. IA 7 of 26. By order dated prayer. instead of the name. As the officer who sought to be implicated. 72.
22.
I has been filed seeking correction. That extent will be. Civil 347, 2026. This court will review that said order, name of Dr. Devi Ekta. Mention. Said name. As the person sought to be pleaded, since said officer is presently holding of additional chief secretary to the government, some child drive and Adivashi welfare department. 6. Say it is ordered that petitioner be permitted. You have not filed. amended-
I have filed, madam, but that was not.
The petitioner be permitted to file amended post title reflecting the name of Dr. P. Kalyanji. As was done in the earlier 7 of 2026. So the past today, I 7 6 shall be read together. Passed today in IA 1014. Read together in passed in IA 347 of 26. Right? After 4 weeks.
Yes, in 2024.
The matter relates to compassionate appointment, my lord. There was a direction passed by this honorable court, my lord. My lord, just for a moment, my lord, can turn to page 15, my lord. There is a mandamus had been issued by this honorable court. Now, page 70, para 7. The respondents are accordingly directed to act upon the recommendation of the SLC and appoint the petitioner to a vacant grateful post after getting the approval of the finance department at the earliest. Lord, this order had been passed on 30/03/2022, and till date, my lord, they have not acted upon. Now, my lord, they have said that the proposal has been rejected. And this is not one of the.
What is the name of the petitioner?
Abdul Mannan.
Where are the names considered? Say that they are rejected.
Last para, therefore, plus case.
What's the content? Without getting a correction of this one. Third, for parties. First in WPC 49980 19. Petition earlier prepared by the petitioner came to be disposed of with the following direction. There are 7. The direction is expected above. It means that there is a clear direction to the respondents to act. Since the point petitioner, they can post to grade 4 after getting it to the panel. There too. Why did you file the writ petition? Because it was pending.
Not, they have not acted upon, almost upon 2024, they are
No,
now,
no. The time when you filed the writ petition,
they did not act upon.
the writ petition was filed because these orders were not carried out by, directions were not carried out by the court. During the pendency of the court, pendency of the writ petition, that a decision was taken by the SLC. Is it the SLC?
Departmental.
Huh?
No, no, sir.
Departmental Committee for
Departmental Committee.
Appointment on Professional Ground. In their meeting held on 7/12/2024, that the cases of the writ petitioners dated 9/20 is also judgment effects. Direction to appoint the petitioner as grade 4. The grade 4 in terms of the prayer made in the writ petition cannot be considered as the challenge, which is not under challenge in the present proceeding. Accordingly, we want to prayer in the writ petition is limited for issuing a direction.
My lord, with all respect, my lord, my humble submission before my lord is that, they are authorized to take a decision regarding the OM. My lord, OM will run from the date on which it will issue. And now our mandamus, my lord, is prior to that. Now, my lord,
For that, this will have to be challenged. That is what we are saying. We are only asking you whether you want to close it and file afresh.
my lord, we keep this pending, my lord, and we
The
challenge.
counsel for the petition, therefore, seeks liberty.
Fine.
Complete his instructions and make necessary amends.
Yes.
Petition.
Fine.
Mr. S. Doctor, revenue. Revenue.
Yes, sir.
Revenue Department, age of 20. It's after 4 weeks.
Fine.
Okay.
Yes. What is this? Well,
As per my telephone instruction, the amount which has been lying in the account of it, then there will be remain in the account of ASMB, right? No, there will be no left after the ending of the financial year. They have one.
then it's all. Get your instruction. Why this amount is not.
So next breakup we have already written. The letter because so and so was written to the finance department. Promotional second instruction for the utilization of the above mentioned amount by from the department is yet to be received.
That is what we have been asking you in your 6th of March letter, that this amount is for 3 purposes.
That's it.
Then why are you asking for instructions?
Because the cabinet decision something different. So we have
When was the cabinet decision taken?
cabinet decision taken on 26/11/2024.
Then
Not early.
24 and 26 you are asking for instructions after having paid a part of it. You have paid already a part of it from the said fund.
No, no, sir. Yeah, oh, yes, sir. We have paid 10 crore from the state fund.
10 crore for what purpose?
So regarding the employee provident fund, new bankers may accept. So yes.
That is the purpose.
And
So
the
you have
return-
paid a part of the amount. Why are you asking for instructions now for the balance? Heard Mr. Reed from mine. State Agricultural Marketing Board, they agreed that their salaries for the period of May
2025 to March 2026.
May 2025 till date has not been released. Submitted that sufficient funds are available in the disposal of the marketing board. In spite of that, their current salaries, their area and current salaries have not been released. Council, standing council appearing to the marketing board submits that an amount 9,75,40 is lying unutilized the bank account of the ASEMP. Waiting instructions from the finance department in view of a decision taken regarding the continuance are petitioners are part of the 136. The counsel for the petitioner was permitted to take instructions expressed by the counsel for the petitioner that lying bank account may lapse considering the financial year ending. The matter was called up in the post-lunch session when Mr. N.J. Communication dated 6 submit and submits that the amount of 9,75,40 which is lying unutilized in the account of the ASMB with the ASMB and will not lapse after the expiry of the financial year 2025. The communication 6/3/26. to the finance department seeking instructions regarding the utilization of the above amount. Further instructions are waited from the finance department. They submitted that salary of the employee. Submissions made at the bar spoken that since the respondents and instructions have submitted that the amount lying at the disposal of the ASMB amounting to 9.75 will not lapse after expiry of the financial year. Separate or specific directions are required to the respondents will obtain clear instructions as to why current and the area salaries rate petitions will not be in spite of the ASAMB. Particularly when the said amount has been received from the government, some for payment on standing and regular salary. Instructions based.
Five and six.
Number 5 and 6, energy moral forest. 1, 2, 3. One. Study to tendency of the bid petition will not be a bar. It's the area and the current salary. Bid petitions, please start with the return.
I'm 100%. Okay.
Chip, I'm waiting for instruction. I'm praying for 4 weeks for the time document.
MSP Sharma, CGC submits the further time.
Dated 9/3. Internal report is directed to instruction from finance department.
Yes, finance. Finance. Any other respondents are required to file their PV?
Already PPO issued, but
PPO issue.
Kejari Kokrajar has not released the money. That's why on the earlier occasion.
Affidavit is ready, lots. We can affidavit receive today, lots.
The rate of the learning state. By the affidavit in this week. Also. Respondent 5. Huh?
4 the government will appear. I'm sorry, man. 5 they will appear, but respondent number 4 service is complete, no one has appeared.
service is complete as per
Order dated 9/3.
service has been completed. PRB 9/6. Inspector of Civil Disposal. 5 is represented by the state government. Represented by the council of the again. We like to file a rejoinder also. The affidavit 9 April.
Public.
In the event the respondent ex parte respondent
I have received one instruction, so I need some more time also. So that this instruction was sent by the DLR. Just forwarded all the documents to the Secretary Revenue Department. That instruction I take some more time.
yes. Council for the revenue inspector. Staff of 4 weeks.
Obliging.
For the respondent here, finance department. Finance department. Fine. And where is the charge sheet?
Charge sheet in the criminal case, no charge sheet has been there.
Then why are you apprehending?
Reply in the department post.
Relying on GM Tank and Paul Anthony.
Yes.
There, the criminal proceedings have have already have proceeded against the here it is not proceeded. What basis are you asking for the protection?
Allegation is same,
Charge sheet has not been filed.
but I have not been able to contest the department.
That is your problem. You contest the state.
I
No, Mr. Counsel, it is possible that the charge sheet may not be filed. Then the protection you are claiming is on the premise that there are two proceedings going against you. What about the criminal proceeding? It's still at the stage of investigation. Then on what basis are you asking for protection? That is on the basis of the judgment which you are rendering to. They are under investigation. You have to satisfy that the charges are same.
Charges are same.
But charges are same will have to be identified only when the charge sheet is filed. Or some criminal matters.
FIR.
Why do you unnecessarily make a submission which is irrelevant? We appreciate such submissions coming from esteemed counsel. The law. But you want to argue on something which you have built up your case. Adamant, we can also be adamant. Dismiss it straight away. Grounds. Dismiss. counsel for apprehending that once the charge sheet is filed, your defenses are revealed, you will face prejudice in the criminal proceeding. Where are the proceedings? It is still at the stage of investigation. Spelled out, what basis are you claiming the protection? Mr. Rai Soikia, learned counsel for the petitioner, prays for it granted 3 weeks' time. Complete his instructions on the matter. After vacation, yes, 22nd of April, Mr. Raj Bola for the finance. Finance and taxation. Yes. Yes, finance counsel. The last occasion you are supposed to obtain instructions. It is not come.
Both the standing counsel are on legs, my lord, in different tools.
What can we do? Only instructions are sought for on 9/3/26. The counsel for the finance department is unable to apprise the court about the status as to why the treasury office, in spite of the PPO being issued by the concerned department. This matter will be listed again on 6th of April, on which date the finance department will price the court. Mr. B. Chakraborty for accountant general. The Banerjee for respondent one. This is 35. Similar matters. These matters will be listed on 6th.
Offline.
Matter be taken up after some time, counsel and responding.
After vacation, this matter immediately after the ensuing week.
Seventh year.
30th April. This one 30th April.
But the other day, the question was regarding jurisdiction, whether this High Court has jurisdiction to act on the basis of which the person was dismissed from service at Lucknow. But the certificate which he collected from Assam Board of Sanitary Education, and we have given several citations. And copy has been also furnished to my learned opposite party friends. Out of this, my lord, 2014, 9 SCC 329, it is clearly said that High Court gave interpretation that Reed Court cannot exercise jurisdiction under Article 226 beyond its jurisdiction, but in para 9, 11, para 6 and para 19, 20, the Supreme Court has said that the view taken by the High Court is no longer practical, and Article 226 of the Constitution provides such powers to the High Court.
So in addition to this, my lord, 1991 4 SCC 270 para 11 and 12, 15 and 16, it is said that High Court has powers to deal matters if occurrence taken place in various places. And there is another judgment of our High Court, that in 1987 to JLR 308 para 10, it is said by our High Court that there was an application of mine at the time of dismissing the writ petition from his service is not tenable in law, and the matter is remanded back. That the service was dismissed at another place, the case was filed in the High Court because part of
We
the
hear you on 23rd April,
judgment,
23rd April,
for judgment.
oh, for hearing and disposal.
On maintenance.
Maintainability. 23rd of April. Yes, you are representing the other side.
Lordship, I'm representing PWD. We are awaiting the instructions.
Sir? DHO. DHO, APS. That instruction. Much time do you
3 weeks may be granted, Lordship. 3 weeks may be granted.
raise for 3 weeks further time? It's again 24th of April.
Five.
For appointment of arbitrator, madam.
You file your objections.
Yes, we file our.
What is the objection?
There is a dispute between the parties, my lord, with regard to camp charges. That is maintenance charges, madam, common maintenance charges.
Common area maintenance. Basically, there is a dispute a lot. Arbitrator may be appointed as well.
But they filed an objection.
Yes,
You are objecting.
I'm not objecting.
Then
Lordship may nominate someone.
why do you file your objection if you are not objecting?
We had taken the grounds, my lord, which will agitate before the arbitrator, my lord.
Heard counsel for the parties. Yes. It's fine under section 11(6). I the petition is submitted that in pursuant to the agreement executed by and between the parties, certain disputes arose, which the opposite party, which could not be resolved mutually between the petitioner and the opposite party, and the opposite party failed to counter the process the arbitration. So when the petitioner and the respondents entered executed an agreement, deed of sale.
yes.
They did a sale.
Deed of sale on 13th of January 2016. Then
Plus 42, my lord, page 20.
what has happened after execution of the deed of sale?
Clause, that is right, my lord, clause 42 may be seen, my lord, page 20, my lord.
Page 20,
Page 20.
0.
There it is. Page
Litigation is here, 0.
down, it's written in the down portion.
Arbitration clause is page 28.
38. Is the dispute which arose.
That is a with regard to my lord, common area maintenance charges. My lord.
For the period of 1st March 2022 in 1220, they pay the CAM charges, common area maintenance. Amounting to
That is, your lordship may come to page 8, my lord. Clause, page 11, general clause 7, my lord.
Which clause? Which clause?
Clause in the arbitration, my lord, the sale agreement, that is clause 42, my lord. 42.
That is the arbitration.
Arbitration,
And which other clause you are referring to?
42, my lord.
42. Where are the CAM charges referred to?
CAM charges, lordship may see in report reply, my lord. So common area facilities, services, and all generally these matters with respect of us keeping and maintenance of the building. So that is, and they have said so in the petition, my lord, page 8.
By this agreement, what have you agreed to?
That is the common maintenance charges.
By the said agreement executed, this party had agreed to sell, transfer and convey second party his right title interest in respect of the space measuring 1389 square feet. Market area standing on the first and second floor within Port's Grand Plaza. Sixteen letters covered by and priced in tag number 45280 and grade 1 patta number 162 Sohor part 5 of the district of Kampu. Rated in PSO column number 178. C1. The description of the rated for schedule appendix. Said agreement. Second party is required to pay the common area maintenance charges terms as prescribed in the agreement. Respect of these charges required to be paid, a dispute arose. Where is your this
Notice is there, my lord.
page number
53.
issued a notice dated 21/5/2025. Respondent authorities. said amount and that same not having been paid. The matter be referred dispute for the dispute by referring it to arbitration, sole arbitrator. The reply to the notice.
Yes, page 60 by.
So, like to be said notice. Giving grounds and reasons as to why the CAM charges, CAM, CAM charges are found to be arbitrary and unjustified. Further, the sole arbitrator, as mentioned in the notice dated so and so issued by the petition, was also rejected. Situated better. Filing this petition on the second would be there does exist between the petitioner and the respondent, where it's clearly provided that in case of dispute, the matter may be arbitration by the party of the first part, the association committee or any person fee of services constituted in terms of clause 14. Clause 14.
Well, that is at page 8, internal page. That upon taking delivery position of schedule space party, second first person, she agrees to but the arbitration 42 months. Clause 42.
In the objection, you have written it to some clause 14.
No, 14 should be done. Clause 42, my lord. 42, my lord.
Considering the submission made, see that there does exist under section 21, ID communication dated so and so. Considering the same. Yeah.
25 lakhs.
23 lakhs. 23 lakh 35,930.
3,35,936. Very small. My lord, he is referring to PK Dekam.
Get data. But the amount is small, therefore we did not get trouble.
No.
Side of the disputes arising by and between the parties, the copy of this order we mark to respective arbitrator, which shall be confirmed upon receipt of written declaration as provided under section 12(1) of the Arbitration. Issue copy of the same, the prospective arbitrator. The matter be listed again. 29th April.
It will be on 30 April, my lord, or 28th.
Or 4th of May.
4th of
4th of May.
my lord. Public. My pay is limited. my lord. Students are typically taking time in school.
Bring your prayer.
But my pay is only for payment of gratuity, leave engagement, GIS and NP. Here, it is a sanction in the year 2024. That sanction amount till today they have not released. Space number 13.
Page number
Page number 31.
Why has it not been released?
I'm paying for the BTC lordship. We have filed our affidavit that we have sanctioned the amount, your lordship. And accordingly, we have forwarded the copy also to the other departments.
Which department have you
Lordship,
forwarded?
if lordship comes to page,
Yes, Accountant General's office. Is it?
it's the last order, your lordship.
Yes, Accountant General and Finance. What instructions have you got? Bring it on record. Have you filed your affidavits? You bring it on record. File your affidavits. File your affidavit. The Accountant General's is represented by Ms. So-and-so. It's that the claims of the petitioner are not sustainable in view of the fact that she is covered under the new pension scheme. The matter be listed immediately after 2 weeks. 24.
Petition speaks on lordship 29/4/26 lordship, wherein the entire list of the candidates has been annexed by the department. Then we will take
Yes. counsel to this health department, health
Yes, sir.
submit the similar issues, matters containing similar issues, matters wherein similar issues are raised, it's fixed on 29/4.
Yes, sir.
He therefore submits that this petition be also fixed and made dictated by the council. This matter along with
WPC 7287 of 2025.
7287 of 2025, 29. 29.
Yes. Highly public.
I have entered IM for correction of the name, the petitioner. In item number 52, Jasmine, and he has been anonymously put. For correction of the name of the petitioner. And come to paragraph number 3,
In which writ petition?
in WPC 123.
What correction you want?
Correction of the name, my lord.
Ah.
And this paragraph number 3, page 6.
Yeah, yeah.
I am.
What is the correct name?
But correct name is Jasmine.
Ah.
JSMIN.
Ah.
And he has been entered in,
You see what have you written in para 3?
yes, madam.
In the sentence which is underlined?
After the name Jasmine, the word he has
What
been-
Jasmine? The sentence which is underlined.
Yes, madam. After the name Jasmine, the word
Is it
was-
Jasmine? Is it Jasmine?
Yes, madam.
Huh?
This is
No, Jasmine.
JASMIN.
Now what is the correct name?
JSMIN.
Yeah, yeah, right. So the name of the petitioner is reflected as this Jasmine. Correct name for who have been Humayun Begum. Therefore, that the prayer made in the eye should be allowed. And also be permitted to take steps to correct. Name. Instead of any Begum. Respondents do not object to the prayer made. Any objections? Well, the prayer made the eye, accordingly, I stands allowed. The petitioner is permitted to file amendment. Incorporating the name, correct name, the petitioner is Jasmine Begum. I accordingly spoke. Petitioner is permitted to take Jasmine Begum. By filing amended post title is
there have been interim orders being passed in both these repetitions. Also, they've been taking time since January to file their application.
I have got the.
That is my last chance to file their application. They're just postponing the.
Labor Department.
Has been appointed except for these two candidates also. On the ground of some thing that was qualified with the school.
Fasting self-control. Arrest WPC number
206 also.
6 of 26. There are still submits. That is, instructions are complete.
Yes, I've got that.
And we'd like to bring it on record by way of an affidavit to place for 2 weeks' time. This matters again. Uh, 29th.
29.
You played for 2
29.
weeks.
Yes.
You have waited till then.
Otherwise, this
Charles is
week,
in 4 weeks.
from 12 minutes again,
So 12.
You
but
played for 2
time is
weeks.
good. You get 12 weeks.
WPC Melod 206, Melod 123 of 2026, where my learned friend is appearing. There I have got the instructions from all the departments, from Labor Department, Health Department, everything. But so far as Melod 20626, there I have got the instruction from the Health Department, all the medical reports. Labor.
I'm not really.
In that case, Melod, from the Health Department, I will find that. Then yes, instructions are complete. Madam. Yes. Well, let it be on Madam 4 in that case. Then after. Yes.
That's the last chance to file their application. Otherwise, whatever is available on record, we'll try and dispose of.
The attempt will be disposed of.
If you like.
I tender my apologies. The instructions are still awaited. For the impending election, the officers concerned are not able to furnish.
After the second. Okay. Thus, he represents Mr. Estimeli for this one.
Can it be?
We lost one for the. Oh, these two fellows.
Yes. We have found out, my lords, that the preliminary inquiry and the regular inquiry, there's no deviation, madam. Everything is just a repetition. Whereas this judgment, my lords, 2013, 436,301. I'm ending on it.
So I think on the last day, wanted you to find out a judgment.
Yes, that is it.
The defense assistant.
Oh, no. After during the conclusion, my lordship had pointed out that there should be no connection between a preliminary inquiry and regular inquiry. This is para 41.
But there is a judgment of this court, at least more than one judgment, where the question of whether the delinquent officer should have been given the opportunity of having defense assistant, I think, is an issue. you are pressing this judgment to submit that the reliance on preliminary inquiry is irrelevant. Where is the reliance there? They have conducted the final inquiry, proper inquiry.
The translations provided by the learned CCC minors. Document C,
I think the records, where are the records?
is on the legs, I believe. Is ascending, descending, descending.
Translations are with you.
Yes, my only, last time, the one, for the, just now one and, 3 minutes, he 1, 2, 3 and 1, 1 minutes. As per the Hindi person, my lord, our translation was something wrong, my lord, so I correct it, my lord. It's 34. It's 34 and 29, my lord.
Of
Translation of my translation, my lord.
statement of Dhananjay Dwivedi. Person who was threatened,
My lord, yes, my lord.
purportedly the person was
Purportedly
threatened.
was threatened.
They have submitted two applications to the concerned officer, my lord. It was Y and Z, my lord. I marked, my lord.
Where is it?
Nine, five, eight, five.
Which part?
Page 29, my lord. This, my lord, the second paragraph, I post number Dhananjay Dwivedi, my lord. I have nothing more than to state in my statement beyond this statement. In the allegation, it was recorded was it was my lord, it could not be, my lord. In the allegation, request letter produced by me on so and so and so. This was, my lord, already in exhibited, my lord. If submit the letter to the authority, my lord, regarding their absence, my lord. For 34 is also, my lord, the same, my lord, statement recorded should not be there, my lord, statement in the illegal. My lord, one another letter, my lord, record, my lord. I've marked, my lord, X, Y, Z, my lord, there's correct mark, my lord. Their deposition, my lord, they have submitted the complaint or like this, my lord, before the authority.
My lord, date is very pertinent. Page number 29 says 28/5. 28/5. Here it says 29.
29 is, my lord, the letter from, my lord, the deputy, my lord. Common. Is there, my lord, X, Y, Z.
You're referring to page number
Page number 29, madam,
29,
and 34, madam.
34.
He has submitted to some petition on letter, madam. On particular day, it was,
Where is that letter?
it is there, madam. X1, X in X, Y, Z. X, Y and Z is their letter. Y and Z. X is this common.
This was exhibited.
Yes.
So from where do you say that? Where are the proceedings of the inquiry?
This is the record, madam.
You'll have to give us a translation of this, the day-to-day proceedings. Day-to-day proceedings are not here, are they here?
Not only last occasion was very that's back.
You have to give us a
Yes.
day-to-day proceeding. And more particularly in respect of the exhibits produced and the witnesses examined. We recorded on so and so date, such and such was produced, so and so. examined.
As this morning, madam, but madam.
Since, heard counsel for parties, since the relevant records are in vernacular, CBC is permitted further time to make complete relevant translation, relevant necessary comparison of this code, big sheets or day-to-day orders passed during the proceedings, recordings by the inquiry officer in respect of evidence deduced, support of the allegations made against. Therefore, we listed again. Stone 5, 5, 5, 5th of May.